A revocable living trust, also sometimes called an inter vivos or inter vivos trust, is a trust in which you, the trust maker or settlor, get to direct how your property will be managed after your passing or in the event you become ill during your lifetime and unable to manage your financial affairs. So in your trust document, you'll name a trustee. That's the person who's going to carry out the language of your trust. And during your lifetime, most likely, you'll be the trustee of your own trust. Then when you pass, you'll name an alternate or successor trustee who will step in and carry out the instructions in your trust at that time. A revocable living trust is similar to a will in that both documents say who receives my assets after I die. Both documents can be amended or changed or revoked at any time as long as I have legal capacity, and neither document changes my taxes during my lifetime. So if I set up a revocable living trust, I don't need to do anything different on my tax return. It doesn't have a separate tax ID number or anything like that. The difference between the will and the trust is that with a will, the will doesn't become activated until after a person dies and the will's been admitted to probate by the probate court. With a revocable living trust, on the other hand, no probate is necessary so long as the trust is properly drafted and your assets are properly titled. Your trust only applies to assets that are owned by the trust. Your revocable living trust provides a list of instructions about how your trustee should distribute your assets after your passing. So I might say in my revocable living trust that I want all of my assets to pass to a charity such as the Food Bank of Iowa. Or I might say I want, say, 50% to pass to my child and the other 50% to pass to a sibling. Your trust language, though, only applies to assets that are owned by the trust. So when your attorney helps you set up a revocable living trust, your attorney will also help you retitle your assets into the trust. So what does that mean? So for your home, for example, if I'm setting up a trust, I might transfer my home from myself to myself as trustee of my trust. I might ask my banks to retitle the name on my bank account to name my trust as the owner, and so on for most or all of my other assets. Then when I die, my backup trustee steps in and says, oh, these assets are already owned by the revocable living trust. And look, I'm the trustee of the trust today. And the instructions in the trust say, sell everything, liquidate everything, pay my expenses, pay my taxes, and give everything that's left to, say, the Food Bank of Iowa or whoever I name as my beneficiary. So the trustee can bypass the probate process, which can be expensive and take a lot of time in Iowa. It's very important to make sure that your attorney works with you to transfer ownership of all of your assets to the trust, or to name your trust or an individual or a charitable organization as beneficiaries for each and every asset, and to keep that updated throughout your lifetime. If there's an asset that never gets retitled into your trust or doesn't have a named beneficiary, then it's possible that you'll need to do a probate for your estate, even if you have a revocable living trust. A revocable living trust can be a really good way to manage your estate if the goal is avoiding probate. Now, in my situation, I own everything jointly with my spouse, and my spouse is named as beneficiary on each and every one of my retirement accounts, so I know that if I die, all my assets pass directly to my spouse. However, if something were to happen to both of us, or maybe I don't have a joint owner on everything or a named beneficiary on everything, that would mean that my children would need to pay for attorney fees and probate court costs and experience the delay and the public nature of the probate process, because everything's public record for the most part. A revocable living trust can avoid a lot of that. As I mentioned earlier, the trust can pass assets directly to the named beneficiaries without the need for any probate, so long as the trust is properly created and my assets are properly titled and beneficiary designated.